Good afternoon and welcome to the thorough newspaper analysis for 10th May 2022. Today we have one article from the Indian Express editorial, which is titled Don't Step Back. Following that, we will have the news update and the legal news, which you know are a part of LawSikho's initiative to keep its students and readers updated with the current affairs that is happening in and around of India, for them to find a better edge when they sit for their competitive exams. So the first article today, Don't Step Back. It is regarding the repeal of the Sedition Act. Now, the Supreme Court has decided to look into the sedition laws that it upheld decades ago in 1962 in the case of Kedarnath Singh versus the state of Bihar. So Section 124A of IPC deals with sedition, and it only refers to disaffection, hatred, or contempt against the government. And the same has stood constitutionality even when the High Court of Punjab and Allahabad had previously stated that it is an exception to the fundamental right of free speech. So what happened is that the SC restricted the interpretation of seditious speech to ones that served to incite the crowd and cause public disorder. Anything else, which we like, mainly we are afraid that the sedition provisions will be used to quell dissent. So in order to curb this, the SC tried to interpret seditious speech in such a manner where it would only be applicable in conditions where the speech in question would have caused public disorder and would have incited a crowd. So it is thus a welcome move that the government has stated that it shall reconsider the provision of law after 6 decades it had held its constitutionality. Now, when we talk of the Indian law, we always go back to the law that is there in UK because our legal system is inherited from the legal system of UK. So looking there, we see that the sedition law was repealed in UK back in 2009. Singapore, which is also one of the English colonies, repealed the same last year. And they stated that the reason behind this repeal was that similar laws were already present. Laws which dealt with inciting crowd, causing public disorder, hampering the day-to-day life and the legal situation of a place. Similar laws were already there to deal with that. Hence, having another separate sedition law made no sense. Now, these two changes are significant because, as I stated, England was the colonizer and Singapore had inherited English law like India. Now, the government has asked SC till date to keep the sedition law. However, now that the SC has decided to look into the need for one, the government has asked SC to defer the matter until the same has been deliberated by an appropriate forum, which is the parliament. However, it must be made sure that this does not serve as an excuse where the government will, put the matter in the cold storage or what we call put it to the bed. So the present government has rampantly misused the provisions of this law against comedians, against public personalities, against journalists, or anyone who has resented and dissented against the policies of the government and the conducts of the government. And several law commission reports and the SC itself has been displeased by the repetition of such gesture by the central government. So the matter is too important. And now that the apex court has decided to look into the repealing of the sedition laws, it must make sure that the same is taken to its logical end and it does not get lost within the bureaucracy and the red tapeism. So for the news updates today, we have first, Rupee hit a new low. The Indian rupee fell to a record low as dollar strength dented demand for riskier assets and foreigners continued to dump the nation's stocks. The rupee dropped as much as 0.3% to 77.1825 a dollar on Monday, slipping past the previous record of low 76.9812 touched in March. Secondly, Rajasthan rated as leading state on MGNREGA parameters. Rajasthan has been rated as a leading state on various parameters on MGNREGA after the state government's decision to give employment for an additional 25 days to the eligible rural families completing the stipulated 100 days in a year. Rajasthan secures the honor of being the best and the leading state on MGNREGA for the third year in a row now. Thirdly, Mahinda Rajapaksa resigns as the Sri Lankan Prime Minister. Sri Lankan Prime Minister Mahinda Rajapaksa resigned on Monday after dozens of people were hospitalized when his supporters, armed with sticks and clubs, attacked the protesters. The country has now faced months of electrical blackouts, shortage of resources and food, and is going through the worst economic crisis since independence. Number four, ministry revives MPLADS rules. While the MPs have been demanding for an increase in the MP Local Area Development Scheme, MPLADS fund, the Finance Ministry of the central government has stated that the interest accrued on the fund shall be deposited in the Consolidated Fund of India. Number five, Justice Sudhanshu Dhulia and Justice Jamshed Pardiwala take oath as the Supreme Court judges. As Justice Sudhanshu Dhulia and Jamshed Burjar Pardiwala Justice take oath, this is the first time ever when the strength of justices in the apex court reaches the maximum strength there, that is 34 judges. Number six, Andaman to get gas-based power plant. The Environment Ministry has approved an exemption to the laws governing the regulation of coastal zones and has paved the way for gas-powered plants to be set up at Andaman and Nicobar Islands. The Island Coastal Zone Regulation ICRZ 2019 limits infrastructural development on vulnerable coastal stretches. For the legal updates today, we have Section 138 of the Negotiable Instruments Act. No vicarious liability for check dishonor merely because the person was a partner or stood guarantor for the loan, holds the Supreme Court. The SC held that Section 138 of the NI Act does not impose vicarious liability on someone merely because they were a guarantor or a partner in a loan. Civil liability under the Partnership Act cannot be extended to vicarious liability under Section 141 of the NI Act, and the same has been held in the case of Dilip Hariramani versus the Bank of Baroda. For the second legal update today, we have order passed by court under Section 36 of the Arbitration and Conciliation Act is an interim order, and it can be modified on grounds of financial hardship, and the same has been held by the Calcutta High Court in the case of Damodar Valley Corporation versus Reliance Infrastructure Limited. In the case, the Calcutta High Court ruled that the financial hardships and financial indebtedness are sufficient grounds for modifying an order passed under Section 36 of the Arbitration and Conciliation Act, which directs that the debtor to deposit an award compensation in cash. The High Court held that the provision should be real and realizable and not illusory. So this was all for today. For free study materials and TNA PDF slides, please join our Telegram channel. You can find the link in the description, or you can also scan the code given here. You can also follow us on our Instagram channels, that is LawSikho.Judiciary, LawSikho CLAT Prep, and UGCnet_LawSikho. For any further information, please feel free to visit www.lawsikho.com. Thank you.